Straight ahead on Law&Crime Daily.
The immediate cause of death is gunshot wound of the chest. And we've listed here, decedent was shot by another person, and in parentheses, law enforcement officer.
Gripping testimony in Minnesota as the trial for ex-cop Kim Potter moves into week 2. And the federal sex crimes trial of Ghislaine Maxwell. We break down the prosecution's case before the defense calls its first witness. Plus, the defense rests its case and closing arguments are on the way in the trial of former CEO Elizabeth Holmes. And the Murdaugh Murder Mystery takes another turn as the disbarred attorney's bond is set for $7 million. Law&Crime Daily covering court cases from coast to coast. Welcome everyone to Law&Crime Daily. I'm Brian Buckmeyer along with Terry Austin. The start of week 2 kicks off with expert testimony in the trial of Minnesota versus Kim Potter. On Monday, the jury heard from a forensic scientist and the medical examiner who told jurors the results of Daunte Wright's autopsy.
And now, Dr. Jackson, based on your training and experience, did you ultimately determine a cause of death for Daunte Wright in this case?
Yes.
And what was the cause of death?
The cause of death in this case was gunshot wound of the chest.
And did you also determine a manner of death for Daunte Wright?
Yes, this is certified as a homicide.
And what is the definition of homicide with respect to your work?
Homicide is death at the hands of another.
And how did you make the determination that Daunte Wright died by homicide?
The examination of the wound and the history provided supported that he was shot by another individual.
Potter, an ex-Minnesota police officer, faces first and second-degree manslaughter charges in the death of 20-year-old Wright. On April 11th, Wright was pulled over at a traffic stop in Brooklyn Center, Minnesota, just outside the Twin Cities. At the time, Wright told his mom he was being pulled over for an air freshener hanging in his rearview mirror. Officers say he was pulled over for unregistered tags. Officers then attempted to take Wright into custody for an arrest warrant. Body camera footage shows a struggle between Wright and the officers. Potter then shot Wright in the chest. He died as a result of the injuries. Potter maintains she accidentally grabbed her gun instead of a taser. On Monday, jurors were shown the gun and the round involved in the shooting.
This is Officer Potter's firearm and the loose cartridge that's in the box, as well as the magazine that was loaded.
Okay. Is this the live round which is taken from the chamber of the firearm?
Yes, it is. I see Officer Potter's firearm. It is a Glock 9mm semi-automatic pistol and the magazine.
What is shown on this part of the exhibit?
This is the cartridge that was said to be taken out of the chamber of the gun.
The jury also saw body camera and squad camera footage of the shooting from multiple angles.
Just stay back. I'll tease you! Taser, taser, taser! Ah, he shot me. I just shot him. You dead? Yes! Okay. I grabbed the wrong gun! I shot him! Oh my God! Him, sit down. Oh my God!
A use of force investigator explained the key takeaways from the body cam footage.
It appeared to me in watching this that there was a manipulation in some way of her holster.
Why did that attract your attention?
I've seen it before on other videos I've watched of officers. I myself have done that when I was on patrol. Just caught my attention. Yep.
And when you're on patrol, what exactly are you believing is occurring on the video?
So I carried the same type of holster that Officer Potter used, a level 2, and it would be my practice at times to, when I was making a traffic stop, unlatch the first level of protection or safety on the holster, just to, I guess, give myself a little of an advantage should I need to draw.
Okay. So essentially, it's a way to, if you had to draw your firearm, you're preparing to do it more quickly.
Yes.
Why would you do that?
It would just make drawing the firearm easier, more efficient.
Okay.
Joining us today is criminal defense attorney Bernardo Villalona and Terry Austin. Bernardo, during Sergeant Peterson's testimony, the prosecution wanted to, but could not let the jury touch the taser. Did that make any sense to you?
So I have mixed emotions as to whether the jury would have been allowed to touch the taser. You know, Brian, from doing trials, that of course any evidence, even if it's physical evidence, can be shown to the jury. And if the judge approves of it, it can also be touched by the jury. So what Judge Chu did in this case is that even though she said they couldn't touch it, she reserved decision as to whether doing closing arguments or at a later time, whether the jury can touch it. It may end up that she doesn't want to put them in a position that she's making them witnesses to the crime by touching the taser and them forming their own opinions of whether it could have been mistaken for a gun.
Yeah, it's interesting because the touch and the feeling of the gun is such a big part of this case. Terry, the defense made a lot of objections. Some were sustained, some were overruled. What did you think of the defense's objections and the judge's rulings?
You know, Earl Gray, the defense attorney, or one of them, made so many objections to leading questions, which basically, Brian, were harmless error to minor points. He could have let them go, especially when you can rephrase it. He objected to lack of foundation. He objected to having testimony that was beyond cross. He objected to everything. And I think that the judge really basically sustained many of his objections. And, you know, she made decisions, I think, that were haphazard. Sometimes she made a good decision and sometimes she didn't. But basically, I think Earl Gray is possibly going to get on the nerves of the jury.
All right, we'll see how that plays out as this case continues. Also in Minnesota, former police officer Derek Chauvin is expected to plead guilty to federal charges in the death of George Floyd. Chauvin faces charges of deprivation of rights under color of law in Floyd's death. He had pled not guilty. Now, a hearing has been set for Wednesday where Chauvin will change his plea. Chauvin is also charged with violating a teenager's civil rights during an arrest, but that case appears to be moving forward. The former police officer is currently serving a 22.5-year sentence after being found guilty in state court of second and third degree murder and second-degree manslaughter in Floyd's death earlier this year. A Texas judge will soon rule on a change of venue request for a former Fort Worth police officer accused in the 2019 shooting death of a black woman. Aaron Dean's attorneys claim the extensive news coverage in Tarrant County will make it impossible to find a fair trial. In October 2019, Dean responded to a 911 welfare call after reports that someone's front door was open. Tatiana Jefferson grabbed a gun from her purse when she heard Dean and another officer walking through her backyard. Dean then fired one shot through the window that hit Jefferson. She died as a result of her injuries. At the time of the shooting, Jefferson was babysitting her nephew. A judge is expected to make a ruling on the change of venue motion at a second hearing set for Tuesday. If convicted, Dean could face a sentence of life in prison. Jury selection is scheduled to begin January 4th, and as of now, the trial will begin the 10th. Still ahead on Law and Crime Daily, closing arguments are set to begin after weeks of testimony as former Theranos CEO Elizabeth Holmes faces a possible 20 years behind bars. But first, the defense will soon make its case after weeks of testimony and dozens of witnesses in Ghislaine Maxwell's sex crimes trial. We zero in on the prosecution's case and what's to be expected from the other side.
Hi, this is Dan Abrams with exciting news for all of our Law and Crime followers on YouTube. You can now get the live Law and Crime Network with YouTubeTV for all of your daily live trial coverage, legal news, expert analysis, and original true crime programs. Subscribe to YouTubeTV today and then locate Law and Crime in the channel guide. And for only $1.99 a month, you can add the network to your bundle. Watch Law and Crime every day with YouTubeTV. We put you in the jury box.
Welcome back. The government rests its case in the Ghislaine Maxwell criminal sex trafficking trial. This after 2 weeks of emotional testimony from 24 witnesses. 59-year-old Maxwell faces sex crime charges stemming from her relationship with former financier Jeffrey Epstein. Maxwell is accused of helping Epstein groom teenage girls for sexual abuse. Epstein, Maxwell's longtime companion, was indicted in July 2019 on similar charges, but died by suicide in prison a month later. 4 of Maxwell's accusers testified for the prosecution, detailing alleged sexual abuse by Maxwell and Epstein. During cross-examination, the defense scored favorable rulings from the judge, who said 2 of the 4 women were old enough to consent at the time of the alleged encounters. The jury also heard from employees who worked at Epstein's properties and his former pilots. The defense is expected to start its case Thursday. Let's bring back criminal defense attorney Bernardo Villalona and Terry Austin to look back on the prosecution's case against Maxwell and ahead to hers. Terry, promises of advancing their careers in education, grooming, and a little black book. How did the prosecution build a case around these pillars?
Those were 2 very important pillars, Brian. The grooming, all 4 of the witnesses testified about the grooming. They said that they were promised they were going to get an advance in their career. They were promised they were going to get educational opportunities. And they were selected when they were at their most vulnerable. So I believe that the grooming was really testified about and proven by the prosecution. The other thing about the little black book is we had the house manager testify about that little black book. He said there were hundreds and hundreds of names in that book, and he stated that they were definitely entered by Maxwell. So I think that they've established also that Maxwell was involved in booking these massages.
Yeah. Now, Bernardo, the defense is expected to put on a massive case with more witnesses in the prosecution. What should we be expecting in their case?
Yeah, so the defense on Thursday begins their defense. And in the defense, they are stating that they're going to call 35 witnesses, so 11 more witnesses than the prosecution called. But the defense is going to bring it back to what their opening statement was. And their opening statement, their theme was money, manipulation, money and manipulation, that and memories. And that's what they're going to bring it back to, especially they're looking to call an expert to testify how memories fade and how it can affect the testimony. It has affected the testimony of the alleged victims in this case. So that's what we expect to see, a lot of expert testimony in terms of memories. And then the other witnesses, let's just call it fluff.
We'll see how this plays out as we continue with that federal trial. Of course, we don't have cameras in there because of federal law, which we can show you more, but you, of course, continue to follow Law and Crime Daily for your update on this case. Switching gears now to Arkansas, where a second at 19 kids and counting reality star faces charges. Jana Duggar is charged with endangering a minor. This comes just days after her brother, Josh Duggar, is convicted of possessing child pornography. The 31-year-old pled not guilty to the misdemeanor that allegedly occurred in early September. Details of the case are closed off from the public for the sake of protecting the minor involved. There is no evidence that Jana Duggar and her brother's case are connected. If convicted, Duggar faces up to 3 months behind bars and up to a $1,000 fine. Duggar is set to appear in court on January 10th. Coming up on Law and Crime Daily, a $7 million bond is set for disgraced one-time attorney Alec Murdaugh. We break down his latest charges. Plus, the founder and former CEO of blood testing company Theranos finishes out her days-long testimony as the defense rests its case. What could come next for Elizabeth Holmes? Find out when we come back. Welcome back to Law and Crime Daily. The defense rests in federal court in California after 11 weeks of testimony in the Elizabeth Holmes fraud trial. Holmes is the founder and former CEO of Theranos, a Silicon Valley lab touted to be a breakthrough blood testing company. Holmes claimed her technology was faster and cheaper than traditional blood testing, but later tests found many issues with Holmes' Edison's device. While on the stand, Holmes claimed she was the victim of a decade-long abusive relationship with Ramesh Sunny Balwani, the company's COO. She told the jury she tried to control nearly every aspect of her life. Holmes testified she wasn't aware of everything going on at Theranos and that she never tried to mislead investors or patients. She ended her testimony by telling jurors her pitch to Theranos investors was about, quote, what we created and what was possible. Holmes was the third and final witness called by the defense. The government did not put on a rebuttal case. She faces up to 20 years in prison and a $250,000 fine plus restitution. Closing arguments are set for Thursday. Now, both sides in the Elizabeth Holmes trial have now rested with summations to begin December 17. So let's have criminal defense attorney Bernardo Villalona and co-host Terry Austin break down what will be expected from each summation. Terry, let's start with the prosecution. What should we expect there?
Well, they're going to have to put together their entire story. They had 29 witnesses. That's a lot of people to talk about. They have to show that she deliberately deceived her investors, her patients, and the doctors, and that she took the money to advance her career. She admitted on the stand, and they're going to have to say this, that the buck stops with her. She also admitted that the machines that she used were not her machines because her machines were failing. She also said that they only performed 12 tests on their own devices. That's not enough tests to say that the machines were working properly. And she even admitted, Brian, that the pharmaceutical logos that were put on the reports were personally put on by her. So if the prosecution can say all of that, I think they're going to be able to tell the story to the jury for a conviction.
All right, Bernardo, let's check out the other side now. What's the defense going to have to present on the summation?
So Elizabeth Holmes, you know, she testified for 7 days. So what Elizabeth Holmes is going to focus on, the defense attorney for Elizabeth Holmes, is that, look, this is just a failed startup. This is some invention that she tried to bring up, but there was no intention to deceive it, that she was being physically and emotionally and mentally abused by this man who had all the control over the company and everything that was being put out there. And because of that, there is no intention to deceive, and you can believe her, and reasonable doubt has been created so to find her not guilty.
All right, those are the arguments on both sides. As we said on Thursday, that's what likely we'll be hearing. And of course, when we get those closing arguments and when we potentially get a verdict, we'll be here on Law and Crime Daily to bring them to you. When we come back, the Murdaugh Murder Mystery, the latest twists and turns in the case as a disgraced South Carolina attorney addresses a judge in Monday's virtual court hearing. All that and more after this. Welcome back. We look to Florida now for an update on the man responsible for one of the deadliest school shootings in U.S. history, Nikolas Cruz. A judge rules the death penalty is still on the table. In October, Cruz pled guilty to the Parkland school shooting where 17 people were killed and 17 more injured on Valentine's Day 2018. Cruz and his defense team requested to remove the death penalty from consideration, but a Florida judge has denied those requests. Victim impact statements have also taken center stage in this case. Cruz's defense attorney says hearing victim impact statements could cause too many emotions for the jury to make a sound decision. Judge Elizabeth Schreier overruled the request. At her hearing on Monday, the defense attorney requested victim impact statements instead be read by a third party.
Having a neutral party read any victim impact statements will minimize the potential for the emotional nature of these statements to improperly influence the jury, because a neutral party will be capable of maintaining appropriate decorum so as not to unfairly and unconstitutionally inflame the emotions of the jury and prejudice Mr. Cruz.
They have a right to be heard, and they have a right to voice their feelings about the uniqueness of the victims in this case as it relates to the impact of the loss of the victims to their lives. It is not an aggravation of the defendant's sentence. It is merely other evidence. There's no reason that this evidence should be diluted because the defendant has asked it to be diluted. The motion should be denied, Your Honor.
Okay, respectfully, DP 43 is denied.
Judge Schreier ruled victim impact statements will not be read by a third party. Jury selection is scheduled to begin January 4th for Cruz's sentencing. The jury will decide whether Cruz should receive the death penalty as a sentence. Switching to South Carolina now, where embattled lawyer Alec Murdaugh is now accused of stealing more than $6 million from clients and his former law firm. Some of the charges Murdaugh faces are related to more than $4 million in life insurance money for his housekeeper who died in 2018. Murdaugh was already facing charges after officials say he tried to arrange his own murder so his only living son would get a $10 million insurance payout. During a bond hearing on the new financial charges, Murdaugh said that he's embarrassed and wants to repair the damage he's done. The judge set Murdaugh's bail at $7 million. His attorneys called that essentially no bail at all. Another judge had previously denied bail to Murdaugh, calling him a danger to himself and others. Murdaugh is a person of interest in the murders of his wife Maggie and son Paul. He has denied involvement. Murdaugh is accused of defrauding over $6.2 million in total. What criminal, civil, and professional repercussions is he facing?
Brian, he's facing all of the above. I choose answer E in this. Alex Murdaugh has so much going on aside from the criminal case that he has now, these potential charges coming up now, as well as, remember, they're still looking into him for any homicide charges having to deal with any of the numerous deaths that have already been mentioned regarding his housekeeper, as well as family members in this case. So I'm curious to see, just waiting to see what's going to come from this.
Now, Terry, can you explain the bond and release conditions? Were they too strict, not enough, or just right in your eyes?
I think those restrictions were just right. I mean, they're strict, but they're appropriate. He can probably, maybe, raise the bond, but if he is, there are some restrictions. So he has to be monitored with the GPS. He has to remain under house arrest. He has to surrender his passport, and if he leaves the state, he has to waive extradition. And importantly, he has to get substance abuse counseling. Now, all of this might seem like a lot to anyone else who doesn't know the background of this case, but like Bernardo said, he's accused of so many different things, and he himself even said he understood people's concerns, and he made bad decisions, and he was at a different place. He regrets those decisions. So I think that all of the bond restrictions make sense.
All right, we'll see if he does in fact bail out. But thank you both, and thank you for joining us here on Law and Crime Daily. We'll see you next time as we discuss justice in America.